for choosing to tune into our podcast. My name is Raqiyyah Pippins, and it is my honor to have the opportunity to share with you a recent conversation that I had with Haijing Hu of the Food and Drug Administration's Office of Dietary Supplements Program. As I'm sure you know, the comments that Haijing makes are her own and not those of the Food and Drug Administration.
Thank you, Raqiyyah. I want to state my disclaimer first. The view expressed in this podcast do not reflect the official policy of the FDA or the Department of HHS, nor does any mentioning of trade names, commercial practice, or organization imply endorsement by the U.S. government. I don't have any financial interest or conflict of interest with any dietary supplement companies or trade associations.
And with that, we hope you enjoy our podcast.
What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
All right. Well, first, we just want to thank everyone for joining us today for our first podcast for the American Bar Association's Advertising Dispute and Litigation section that deals with the FDA's perspective on dietary supplements. I am very, very, very pleased that we are able to have a great person join us today who can give us some inside information for responsible companies who are really trying to navigate the emerging space for dietary supplements. And that is Haijing Hu. Haijing joins us from the Food and Drug Administration, in which I know you shared with me that you guys have a new title now. I'm going to try to get this right. You are now the Chief of Regulations Implementation Branch in the Division of Policy and Regulation Implementation at the Office of Dietary Supplements. And so thank you for joining us. I have to ask, how does it feel to have this new title? Has it changed your role in any way?
No, it doesn't change my role. It just after the reorg, we have a division. Previously is office and then staff. Our office grew. So we now have office, division, and the branch. Mm-hmm. We have more people too.
Should we read into the fact that you have more people? More people mean more enforcement?
No, I wouldn't go that direction, but dietary supplement is important. So the agency care about the regulation and the safety of the product. That's one of the reasons our office grew.
Okay. I should ask you, I know I didn't ask you in advance, how long have you been at the agency?
I've been working at FDA for more than 10 years.
Okay.
So I work in the Center for Drug Evaluation and Research, Center for Device Radiological Health, before I joined CIPSEN. Okay. I work at CIPSEN for more than 2 years at this position.
Okay. Well, one of the things that I know people are really curious is, and I know you can probably speak from this from a broader level, having been there for 10 years, but how do shifts in the administration, or now we've heard about a nomination for the new commissioner for FDA, does that change in any way the enforcement priorities? And have you seen a shift in the Biden administration specifically in enforcement priorities related to kind of the marketing and labeling for dietary supplements?
No, a change in administration does not have effect on dietary supplement enforcement. The agency's primary goal is to protect the public health, and our enforcement is based on the Federal Food, Drug, and Cosmetic Act, FDCA, and implementing regulations. Our enforcement priorities are aligned with the perspective of the consumer, i.e. consumer safety, product integrity, and informed decision-making.
Okay, I know you all have to say that. I'm not going to push you on it. I know sometimes it can feel as if there's a shift in enforcement priorities. Do you feel as if maybe there's been an increase in the types of claims that are being made that require FDA to speak up a little bit about what's appropriate for dietary supplements?
No, I really don't feel that way, and I don't think it's happening anyway. Really, we're rely on the FTCA and regulation already established. So unless there's some change in the law and in the regulation, there won't be any change in the way we do the enforcement.
Okay, so maybe I should ask this a different way. So we understand that the regulatory standards that are being applied to dietary supplement claims have not changed because they come from statute. I think one question that people may have is that are there certain categories of products or certain trends that you're seeing within the dietary supplement space that are violations of the Federal Food, Drug, and Cosmetic Act that you feel that sometimes maybe a company should be reminded of, or you guys want to highlight as being violative in some way?
Okay, so our conversation will stay with commodity dietary supplements, right? So I'm going to only talk about this type of product. As I just mentioned, consumer safety, product integrity, and informed decision making. That's the three things we work on. Let's see. You mentioned there's some claim-related warning letter. So I think there's during the pandemic, we noticed an increase in dietary supplement making claims to prevent COVID-19. And as a result, FDA and the FTC, Federal Trade Commission, sent numerous warning letters to this company about this claim. And we continue to survey the market for dietary supplements making disease claim for COVID. So that's one thing about consumer safety and informed decision making. We want to make sure dietary supplement making the claim that's allowed by the law, not violative disease claim.
Okay, so COVID, any other disease areas that you started to see or that you consistently see dietary supplement companies or companies that claim they're selling dietary supplements but are, really selling drugs pursuant to the statute, are kind of diving into that you might want to note or you're comfortable sharing?
Well, I can share the previous initiative we did on the depression. So also that's related to the pandemic, the stress of millions of deaths, economic consequence, and curtailed social interaction leads to an increase in dietary supplement product marketed for a person's well-being. Some of these products were labeled with claim that the product could treat depression and other mental health disorder. So we send out warning letters to 10 firms regarding these violative products. Dietary supplements making false misleading claims that a product is effective against medical conditions is considered health fraud, and the agency continue to take action against companies that seek profit from consumers' fears by selling dietary supplements product with disease claim. And this type of product, it's particularly concerning because in many cases, the use of such product may delay appropriate treatment of an individual's medical condition. So that's what we meant by informed decision making and the consumer safety.
I know this is a long shot, but I'm going to ask you anyway. Is there any way that you're comfortable sharing how those companies came to your attention? Is it from research that the agency did on its own, were complaints from consumers about these products? Or people are always curious, how did these 10 companies get on their radar? Any insight you can provide about that?
So in our work, we look at different inspectional findings and we have structure function notifications. So we kind of know what are the violative claims on the product in the market. We will do a market survey. Well, let's back up a little bit. So we look at these different claims and we prioritize different claims. So if a product says it can treat cancer, That's very concerning.
Mm-hmm.
So
I think if it's creating cancer, I'm concerned too. Right?
not creating, trading.
Yeah, creating. No, I know. We knew what you meant. Go ahead.
So this kind of claim with more safety concern have higher priority. And then we will do a market survey and see how extensive the problem is. You mentioned how did that 10 firms get onto our radar. So when we do market survey, we will find maybe 10, 15, 20 firms. And we will look at the information, evaluate them again, working with other offices in FDA and maybe with FTC. And we'll determine which firm will send a warning letter.
I'm glad you mentioned the FTC because we are going to ask a little bit about some of your joint enforcement. I'm just curious, the market survey, is that done internally or do you guys partner with like third-party research companies like a company would to do a market survey?
Right now, the example I just gave on depression, that is internal market survey performed by my staff.
Okay, with your increasingly growing staff. Yes. So no, I'm glad you brought up the FTC. And I mean, it's not new that the FDA and FTC collaborate on certain types of products where there's high risk, both from the safety perspective and from unsupported claims. But I think the way that you all came together with COVID-19 and I would think the focus on mental health and other issues really is a great opportunity for us to talk about why you two collaborate in particular instances. And, if you're comfortable, I think we'd love to hear, when you do your market survey and you look at products, when do you just elect to say, why don't we see what the FTC thinks about this? Or is this a collaboration in some way? Can you share a little bit about that process?
If you don't mind, I would like to use diabetes claim initiative as an example. As we mentioned, we do a market survey and look at the claims. Diabetes is, according to the CDC's 2020 National Diabetes Statistics Report, more than 10% of the US population have diabetes. So the prevalence of the disease and the economic impact of the disease increased over the year. Now you understand why it's one of our priority.
Yeah.
To find product with diabetes claim. So we did a market survey first. Found I'm not going to give you the number.
It's okay.
The exact number.
We want you to come back, Haijing. We won't push you. We just
we find numerous firms product making diabetes claims. And after we determine the extent of the violation, we actually reach out to FTC and see if the two agencies want to joint take action. And diabetes is a good example because we did decide to take action jointly, and you saw the warning letter.
Yeah, I remember with the caffeinated alcoholic beverage. I mean, there have been other examples over time, and I know one question we often have: who starts it? Is it FDA looks at something and they reach out, or does the FTC find something and they reach out? I guess it can go both ways.
It can go both ways. So diabetes is just an example I use. We actually started. And I think there are some COVID cases FTC started.
Mm-hmm. Mm-hmm.
FDA, we have exclusive jurisdiction over the safety of the dietary supplement, primary jurisdiction over the product label and the labeling, include packaging insert and the other promotional material distributed at the point of sale. FTC, primary jurisdiction over advertising of dietary supplement. So both can have jurisdiction over the labeling.
I'm going to ask this question, which I'm not sure if you'll know about this at all, but when you were talking about jurisdiction between the FDA and FTC, I know one thing that the FTC has been very, very focused on is influencer marketing and social media. And I know the FDA is doing some research more in the pharma context on that. When you're, I guess, in the Office of Dietary Supplements, you're primarily focused on labeling, especially with the exception, I guess, of intended use. You can look at anything for that. But does social media, like influencer postings and stuff of that nature, influence y'all's decision making at all? Or do you find yourself limiting your scope to traditional labeling when determining whether there's a violation?
Okay, that's a case by case decision.
Mm-hmm.
So social media, yeah, I'm not sure I'm the best person to speak to this.
That's fair. And I don't want us to push outside of that, but it triggered a question for me when we were talking about FTC jurisdiction versus FDA jurisdiction.
Yeah, so if, let's just say social media with violative claim, misleading information can be used for FDA enforcement action.
Mm-hmm, mm-hmm. Which I can tell you, we try to tell them as in-house, as outside counsel, as law firms, we we say that at times. So hearing you say that is good too.
Well, thank you for explaining that to the industry.
Right. Okay, so I think another thing we wanted to check in is that we've noticed an uptick in the agency's action, or it's not even always formal enforcement action. Sometimes it can be a untitled letter or warning in some ways, but directed at retailers, including some recent warning letters to Amazon and Whole Foods. And I'm just curious, can you share a little bit of what sparked this focus on retailers, and does the agency see itself developing any like retailer? Because I guess in some ways retailers can be private label distributors, but can you see any retailer specific guidance that the agency may be giving? Because their position with the product is a little different than the traditional, manufacturer or distributor who focuses on one category of product.
Okay, thank you for the question. So first of all, I'm not able to go into details regarding these specific cases, as we don't publicly comment on firms mentioned in the advisory letters.
Of course. I had to try. Go ahead.
At this time, FDA does not intend to issue guidance regarding the topic in the Amazon or Whole Foods or this advisory letters. I believe that's a letter you mentioned, right? Mm-hmm. You referred to. Mm-hmm. FDA issues guidance document to explain the agency's current thinking on the topic. And this guidance document helps stakeholders, including industry, to understand our interpretation of a policy on a regulatory issue. I would say I recommend firms to look at FDA website and find all related information to understand the FTCA and regulations. All this guidance are available on FDA website. Also, I want to give a little bit information on how the guidance is developed.
Oh, no, that would be great. Yeah, please.
If the agency determines that a guidance document is necessary to better inform stakeholders regarding the agency's thinking on an issue, the agency will generally issue a draft guidance, review and consider all substantive comments from stakeholders, and then issue a final guidance. The regulations allow stakeholders to comment on the guidance document at any time, even if a final guidance already have been issued. In addition, stakeholders can contact the agency if they're seeking to better understand the agency's position on an issue.
Is there any way for a stakeholder to contact the agency and it remain confidential or not discoverable via FOIA? I guess pick up the phone is the answer to that. But I think sometimes stakeholders may want to get more information, but they're also concerned about it becoming public, the question.
Oh, well, I'm sorry, I'm not the best person to answer that question. I really don't know the rule for FOIA. We do get FOIA requests from time to time, but yeah, I don't remember if anything related to an inquiry will be FOIA. I don't remember.
Any particular guidance documents that are coming down the pike that you can share that are related to dietary supplements?
I prefer not to answer that question.
That's fair, but we should stay tuned to the website and the Federal Register.
Yeah, stay tuned to the website because there's a lot of factors, moving parts to determine what guidance to work on and what guidance to finalize. It's not an easy, simple process.
Well, as part of that, I know that in more of this might be more in the food space, the conventional food portion of CISAN. I know a lot of us are anticipating a rule of guidance, so rulemaking about changes in nutrient content claims and healthy, et cetera. And some of that was sparked actually by litigation, like state-based litigation, alleging that certain claims were false and misleading under state law. And companies became a little confused or frustrated in certain instances because they felt that their labeling practices were technically compliant with the FDA's implementing regulations for the Federal Food, Drug, and Cosmetic Act, but those don't have preemptive effect. So there would be state-based litigation. And one of the things that we're just curious about is, whether or not in the dietary supplement space, your office has been noticing some of the litigation alleging that dietary supplement labeling is false and misleading. I know there was the Aurora case that involved this position that the DSHEA disclaimer had to be on every single panel where the claim was based on their interpretation of FDA regulations. And there have been some cases that deal with how to define the amount of protein in a product and things like that. I'm just curious, we're curious, does the agency follow these cases at all? And are there any steps that firms could take if they wanted to have FDA help clarify how the regulations are supposed to be applied, or, in any way help to ensure that the FDA's policies or regulations are not being misread or applied inappropriately? Because I think in those cases in particular, industry has sometimes felt as if it involves a plaintiff's attorney who has misunderstood the intent behind your regulations and judges that aren't as familiar with the act. I know this is a tall order to ask, but since we have you here, Haijing, I'm just curious if you guys are even aware of the cases or any case, how does that work? Do you pay attention to litigation? And if someone wants you to comment, maybe send some type of, I would say admit something as from a judicial notice perspective, or help to clarify issues. Is that even possible or feasible?
Well, thank you for mentioning these cases involving certain food and dietary supplement regulations. As I mentioned earlier, FDA does not generally discuss specific case product label with a third party besides the responsible firms. But we can provide some advice on this kind of issue. So FDA does provide general information about our food labeling requirement. And the agency publish rules that establish, modify the way it regulates food, including dietary supplement. And these rules are formed with public input. Any stakeholder can participate in the rulemaking process by submitting comment on proposed rules, and this comment are usually submitted online through regulations.gov website. We carefully consider all substantive comments when we draft the final rule. Firms should be aware of the rules pertaining to labeling of the food. For example, firms can make claims that are related to nutrient, as you mentioned, the nutrient content claim. And there are specific regulations for this type of claims, as noticed in 21 CFR 101 subpart D. This rules provide the firm can petition the agency to take other actions, such as ask that the product be exempted from a rule pertaining to the nutrient content claims. Another way firms can be involved in the regulatory process is to file a citizen petition asking the agency to issue, change, or cancel a regulation, or to take other actions such as issue a guidance document. We mentioned about guidance document earlier. The agency probably receives about 200 petitions every year. And the company should also be aware that FDA sometimes schedule public meetings and hearings to discuss certain issues. This usually held with industry representative or consumer groups, but any interested party may attend with advance notice, provide comment on a proposal. These meetings are announced in the Federal Register. And we recommend firms to be familiar with all the rules and regulations.
So in other words, we have to get we're involved in the rulemaking and legislative process on the front end, then maybe we'll have the clarity that we need by the time the lawsuit is filed.
Well, we do want to have every stakeholder's input before we have a new regulation or new guidance. We want to hear from our stakeholders.
And the good news is that stakeholders want to be heard, and so I know we've been helping some clients with comments on a variety of rules and guidances, and are really paying attention to your agenda to see if new opportunities come to influence the way that claims are being made going forward. I mean, I think that the FDA's food innovation strategy it's more in the conventional food space than dietary supplements, but it's an acknowledgement that information and communication is modernizing. And so we could take another look at some of former policies and see if they could be updated consistent with the approach to consumer health and education in the 21st century. Wow, I can't believe that. I think all this time has gone by. I want to make sure before we wrap up that I ask you, like, what would you, this is your time, Haijing. You have this really eager audience that does not want to be one of the companies that you send a warning letter to. And so the question would be, if you had any advice that you could give to a responsible company that is attempting to educate consumers about how they can use their dietary supplements for health benefits and other things, but want to avoid FDA's crosshairs, what would be your tips for them on how to kind of stay off your radar while still being able to make claims?
Well, FDA is responsible for assuring that food, including dietary supplements sold in the United States, are safe, wholesome, and properly labeled. This applies to food produced domestically, as well as food imported from foreign countries. And the FDCA and the Fair Packaging Labeling Act are the federal laws governing food products under the FDA jurisdiction. FDA has authority to take post-market action for violation of the law, as you mentioned. A dietary supplement firm must comply with regulations regarding facility registration, new dietary ingredient notification, labeling, CGMP, structure function claim notification, and adverse event reporting. The firm's primary responsibility is to ensure that its product will not cause illness, injury, or death. The firm is also responsible for the integrity of the product, meaning the product contains what the label says, and in the right amount and nothing else. Several advice, suggestions I can make to responsible firms. Firms should visit FDA web pages dedicated to dietary supplements for additional information regarding responsibilities, submission applications, and guidance documents. This website also includes links to the text of applicable laws and regulations. So it's recommended that manufacturer, distributor, and importer become fully informed about all these requirements before they offer the product to sale. And if they require assistance, they can contact the most appropriate FDA small business contact. You can find that information from FDA website too. It's a food industry's responsibility to remain current on legal requirements for food labeling, as we mentioned. And all the new regulations are published in the Federal Register prior to the effective date. Firms may also benefit from reviewing the publicly available agency's database of warning letters to gain an understanding of the type of possible violation by dietary supplement manufacturer and the distributor. If any violations cited in the warning letter may be applicable to their product, facility, or operations, we recommend that responsible firms voluntarily address these issues. Likewise, firms can also find information relating to structure function claim notifications and related courtesy letters, new dietary ingredient notifications by visiting the website regulations.gov. FDA provides a free email alert service for important FDA news and information as it's become available. This is a long website, public.gov/accounts/US FDA/subscriber/new.
Okay, and if they can ask questions. If someone needs that, you can email me, Raqiyyah.Pippins@arnoldporter.com.
Yeah, that's a long website.
Go ahead, yeah.
I think it also may help to add a little bit about inspection.
Mm-hmm.
FDA conducts either a surveillance inspection or a forecast inspection of a dietary supplement manufacturing facility. A knowledgeable person at the facility, preferable, designated ahead of time, should accompany the investigator at all times. It is the firm's best interest to fully understand FDA's inspection procedure. We have two documents, Compliance Program Guide Manual, CPGM, and Investigations Operation Manual, IOM. Both provide useful information for inspection, and both documents are available online. If a firm receives an FDA 483 list of inspectional observations, the firm should respond to the 483 within the timeline given and provide any correction and supporting documentation. I want to emphasize that it's critical to provide the supporting documentation for each correction. And my final point here is firms need to ensure their products are safe, properly manufactured, and accurately labeled. Responsible firms should follow all these requirements and periodically recheck their products and operation.
Oh, Haijing, thank you so much. It's interesting. I really love how you emphasize that even when thinking about labeling and misbranding issues, safety is still the most important thing. And I mean, that makes sense. FDA is a public safety agency. That's your focus. That's your priority. And it's really helpful, I think, as people try to understand enforcement priorities, to think about, well, what is going to bring the most risk to consumers from a harm perspective? and that would guide them in some way. And that you guys look at everything that's submitted, structure function notifications and your inspections. Even if you don't act immediately in those instances where it's received, it can inform you on the trends and how you'll act in the future. And so on behalf of the ABA's Advertising Dispute and Litigation section, we just want to thank you for taking the time to speak with us today. We hope you'll come back and we haven't scared you off in any way. And we also want to say thank you for helping our clients stay out of trouble, reminding them of the law.
No problem. And thank you for the opportunity to be here and discuss the regulations of dietary supplements.
Definitely our pleasure.
We hope you enjoyed this episode of Trust in Trade, brought to you as always by the Antitrust Law section of the American Bar Association. Now you know that's the T.